Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Dono, attorney at law, and once again, I'm happy to be here. I'm happy to bring the law and you. Of course, you can watch us at all stations on WESN-CC, as well as Strictly Legal with RondellDono.com and our major podcasts. We have a next exciting episode, and I have no stranger to this set, and his name is Mr. Farai Hove Masaisai of Hove & Associates, attorneys at law. And today we are going to discuss the topic of defamation in the digital age. How do we navigate this legal landscape? And of course, this is coming or stemming from a recent judgment that was just last week handed down by Justice Margaret Mohammed, where a social media blogger has been ordered to pay over $1 million to the North Central Regional Health Authority CEO, Mr. Dalvin Thomas, for defamation or for defaming him in a series of Facebook posts in 2020. And the decision was handed down just recently. And of course, I will have Mr. Masaisai just explain more. And of course, we go into how can this now, defamation and technology, how has the law basically expanded in this regard? Good day, Farai.
Good day, Mr. Donowa, and good day to your viewers and to your listeners. It's always a pleasure to be on this leading legal show, and definitely thank you for having me here today.
And it's a pleasure to have you, and I think you are probably the most frequent guest at this, almost as though you are my co-host.
Almost.
So thanks for taking the opportunity to be here. And of course, as I said, the topic today is defamation. Yeah. And first up, let me congratulate you and your firm, Hove & Associates, for leading the charge in this case once again on defamatory statements made via social media.
Correct.
Right. So let's discuss in terms of what exactly happened in this particular matter.
All right, so this is a judgment handed down by the High Court, Justice Margaret Y. Mohammed, on the 28th of September 2023. So it's a very recent judgment, and it's a very important judgment in that it adds to our legal jurisprudence in terms of the development of defamation and libel at that, where it comes to social media or posts on websites. Yes. The social media forum that this defamer chose to use was Facebook, but the principles of law would also apply to, say, Instagram and Twitter, and even these days WhatsApp. All right. So yes. So we in this matter we did represent the CEO of the NCRHA. He was defamed over a period of about 5 months. About 5 months.
That's a long time.
Yeah. So he had a broad back, patience of Job.
Wow.
All right, but he in that he was gathering his information, meaning the posts were up, the statements were being made, the libelous statements were being made by third parties. They were being republished. They were being shared. So he gathered his information wisely before making his claim. We would have sent a pre-action protocol. And the defendant would have issued an apology immediately. That would have been done through my instructing attorney. So there's a process in terms of before you go to court, you try to warn people first. But with defamation, sometimes you warn people and the damage is already done.
Now, if we can stick a pin just to get an overview of what constitutes, let's start with what, I know we did a program before, but what constitutes defamation?
Okay, so defamation is really tarnishing someone's character, bringing them down in the eyes of a third party. So as between myself and yourself, if we have a conversation without the cameras and I insult you or defame you, that is not defamation. It has to be said to a third party. So a third party has to be in the room to hear it. So even though you and your friend may argue as between one another, so long as it's not via emails where persons are copied or via social media where the whole world can see, that would not be constituted a defamatory statement. So it's really just saying things that will reduce someone in the eyes of a third party. And that is what they call defamation. And defamation comes in two forms. It can either be slander, where it's words said but no broadcast, and it can be libel, where it's words said or even words published. When I say published, it could be written or typed up, and it's sent out to a third party. So and there's a fine line with slander and libel when it comes to radio. So if the radio station has that, normally it should have a 15-second lag before things go out into the whole world. If it is they operate that efficiently, then certainly the slander would not get out. All right, so that would just be considered slander as opposed to libel. But if it goes out after the 50, then it will become libel, and libel carries a higher form of damages than, say, slander, because they view libel as being it's hard to bring back.
It's a permanent. I mean, it's a permanent structure. I mean, it's something permanent that is always there and will always be there.
Correct.
Regardless of if the defamer takes it down.
So even when persons say that, watch, my lord, my lady, I have deleted the post. Sometimes we find it because somebody shared it or somebody screenshot it and put it somewhere else. So once it's out there forever, and certainly it's hard to fix a good name. And that's why the courts over the years have keep increasing the damages awarded to persons when their name, their character has been defamed, because the nature of it is that persons would work their entire life to keep a good name.
And does it have to be a popular individual or someone who's
certainly the more popular you are, the more damages you will get. But even if you are unpopular, and I use that word very guardedly, because everyone thinks they're popular. Even if you are not an influencer,
yes,
you can still be compensated for your name. You may not get the million that Mr. Thomas would have gotten, but you certainly would get some sort of damages in tune with your reputation.
And coming back to this instant matter, in terms of the Facebook post, if you're at liberty to just state quickly what exactly were the statements that
these were proper. The judgment is 70 pages. I'll put it in context.
Yes.
And in the judgment, the judge is compelled to restate verbatim what was said. So there were proper statements that the author thought was fact, which we were able to prove were false.
And what were the accusations?
They were accusing the CEO of misappropriating funds. Now, these defamatory statements took place in the heart of the COVID-19.
Okay.
The CEO of the NCRHA being the largest regional health authority in our jurisdiction, would have been in charge of the government's fight against the COVID-19 virus. And I know he always says that while he was standing in the gate of life and death,
right,
someone was there, an armchair journalist, there to defame his good name.
We have plenty of that.
So that being said, that was the context in which the defamation came. So he was doing his job as best as he can. He was in charge of the Mount Hope Hospital. He was in charge of the Couva health facility and all the health facilities throughout the East-West Corridor and Central Trinidad. And at the same time, he had a lot of responsibilities. What the author was questioning was how he was conducting his affairs, accusing him of nepotism, accusing him of political victimization, accusing him of fraud, accusing him of mismanagement of public money.
And these posts were from March 2020 straight to June 2020. Couple instances, 24th of March.
For quite a long period of time.
25th of March, 30th of March, April, and it's just going on and on.
Correct. So some of the things that he was suggesting to third parties, meaning the entire Facebook universe, was that the CEO was mishandling public funds. He misappropriated public funds. He defrauded the state for his personal benefit. He favors P&M contractors. He's a liar. He's a fraud. He's a criminal. He received kickbacks. These were things that were said and were found to be false.
Because obviously, in his defense, I mean, the defense of defamation is the truth, not so? And proving.
Well, in this case, he did not raise a defense of justification. He raised a defense of Reynolds privilege. which is a journalistic defense for responsible journalism.
But therefore, does he qualify does he pass the qualification of what is a journalist? So does he,
Well,
I
don't think the judge even had to go there. Under cross-examination, he admitted some of the posts. So most of the posts that he posted was admitted, but only under cross-examination. That's why a good thing is to get a good attorney.
Correct, correct. Because you were able to elicit that evidence from him.
Only under cross-examination.
Yes. That's the trick.
But for that, then the court would have had to look to see if he was a proper journalist in accordance with the Reynolds privilege test. Journalists in our jurisdiction are really the responsible journalists. And I would go as far as to say the Guardian medias, the One Caribbean medias, the different radio stations and so forth.
You mean in terms of who are legitimate?
Who the courts will consider as legitimate.
Okay.
All right. But there is a test in Reynolds privilege, and you have to exercise what they call responsible journalism.
Yes.
So what part of that test he would have failed abysmally, in that even though you are aware of information and you think the public would have a reasonable expectation of receiving that information, a responsible journalist will reach out to the person who they have the information on for a comment. So you'll hear in all reports, they would say, well, we tried to reach out to the Minister of Finance and we didn't get a comment at the time of running the story.
Yeah.
But they tried.
Yeah.
So that is what a responsible journalist does. They at least send a WhatsApp to the person, say, watch, this is the article we intend to run. Let us know your side of the story by, say, if the news is at 6 p.m. or 7 p.m., let us know your side of the story by 5 p.m., please, or as we intend to run it. The court will see that as responsible journalism. If you choose not to respond to the journalist and then you respond only in court, then the court would say, well, they have a defense. All right? So his defense was Reynolds privilege and fair comment. He said the Mr. Davlin Thomas is a public official and he's open game. It need to be thick. But I think that open game defense works more with politicians. Davlin Thomas is not a politician in the purest of sense, in that he does not get a protection from any parliamentary privilege. So a lot of politicians, they will go and voice their dismay in Parliament where they are protected by what they say in Parliament. All right, Davlin Thomas didn't have that opportunity. And one of the leading cases would have been the Prakash and Prakash, where the two brothers defamed one another in a political environment. And the Privy Council would have said, watch, as politicians, you need to have a little banter. Mm-hmm. Your skin had to be a little broader, your back had to be broader. So it works amongst politicians, that defense, but certainly not with a lay person and a officer who's not elected.
Yes. Yeah. And basically, obviously, the court found one that they did not take into consideration his defense. Right. The judge took into consideration his defense, but found that it was not made out.
Made out,
correct. Yes, yes. And that would now render your case successful to that extent. Now, in terms of the trial, how long did the trial take place, and whether there were any witnesses?
Yes. So for witnesses on our side, we had Mr. Thomas, and he had a colleague, Mr. Robinson, Kwesi Robinson. So his witness was really to his character. So you need to have a character witness if you're saying that you're a person of good character. So you cannot defame someone who has a bad character.
Yeah.
So if someone is a known thief and you call him a thief, and you have a judgment from the court saying what he had been arrested for theft and served time, then he cannot go and sue you for defamation for calling him a thief, because you'll be speaking the truth.
Yes.
So yes. So you have to have someone to at least speak to your character. Naturally, you can speak to your own character, so we would attach your CV, attach his accomplishments. So apart from being the CEO, he was a former councillor for Barataria. He's still the vice chairman of the National Carnival Commission. He serves on different committees. He's in the arts, the performing arts. And his name is well known. So we put a dossier in terms of his work and his nationalistic work. So it's a name that he cherishes, and certainly he has children who carries his last name, so he would want to protect it. So that goes in terms of, but in terms of how the trial went, The trial was 1 day. It was a 1-day trial. And the other side they didn't bring any witnesses except themselves.
Right.
So you brought yourself, and naturally, if you only go by yourself, your evidence will be seen as self-serving because you're going to defend yourself. Normally, you bring witnesses.
That testify to your character, to the truth of the issue. Or
correct.
To
so if you're saying you're a journalist, you should bring your producer, the person who you work for, if you're a journalist, to build your credibility. The other thing was that he was flip-flopping on his defense, meaning initially he apologized via email and then he withdrew the apology.
Oh, that's a question I was going to get at. Okay, I mean, I know one of the reliefs that you would ask or the asks
for an apology,
and whatever damages to be agreed. So he
initially apologized.
He apologized, right?
Yes, and then he said, when he retained counsel, he indicated this was his story, which the court found to be false, a fallacy. He said how someone hijacked his Facebook profile. All right, so this goes out to anyone who wants to defame and say that somebody hijacked your Facebook or somebody hijacked your laptop and they defame. He said the person's name was Johnny Walker.
Yeah, that's a famous Facebook name.
So Johnny Walker hijacked his his Facebook, and Johnny Walker did most of the posting. So he admitted to some, but not to all. And then he withdrew the apology for the ones that he said Johnny Walker did. But on the balance of probabilities, which is the test in the civil arena, the judge found that there was no such Johnny Walker hijacking his Facebook profile.
Because obviously, I mean, that's
for such a long time.
To prove
March
that
to June. So what? Even when from March to June, you didn't report it to Facebook that someone has taken control of your Facebook profile. There was no evidence of that.
Yeah.
The post came from Ramesh Siwa, and certainly that was the findings of the court.
Wow, that is interesting. Poor Johnny Walker. Right?
Johnny Walker. I think that's our alcohol.
That's precisely.
Yes.
Yeah, it's a famous name. And let's get in terms. Okay, so the court was on the claimant side in terms of their claim. Now let's deal with how the court assessed the damages, because it's quite a large number, almost $1 million. Well, when you look at costs, it probably is $1 million.
It probably crossed the million, because the court awarded interest at 2.5%.
And then we have seniors costs as well.
And then on top of that, you have statutory interest at 5%.
Was this cost assessed or
no? The court gave liberty to apply if you wanted to be assessed, but the prescribed cost was pretty much.
Well,
it was over 100,000 in prescribed cost. So
right.
in these circumstances, I would not insist. So you can insist on your cost being assessed. So there's a difference between assessed cost and prescribed cost. Prescribed cost is generally lower. It allows for access to justice so that persons would know with some level of certainty, based on the value of the case, how much cost they will have to pay to the other side if they lose.
Yeah.
With assessed cost, you really pay based on time spent by the attorney on the other side, and it normally runs up. It'll probably run up at least, a case like this would probably run at least 4 or 5 times the prescribed cost. So in this instance, we say the overall figure is okay.
Right.
It's okay.
Well, I mean, more than enough, of course.
It's okay. It's okay.
When I say more than enough, because you're really high, you make the more expenses you have, etc. Yeah. If you have counsel to pay, if you have this and that, the other. But of course, in any event, you can't measure. You can't measure reputation addition. You can't really measure what the amount of work an attorney does compared to the monies that they receive. Yes, the people may say, well, attorneys get a lot of money, but it's a lot of work. It's a lot of late nights. It's a lot of early mornings.
Correct.
Yeah, especially, having a family and still having to deal with your job, or having multiple different matters to deal with at the same time.
Correct.
Because the law is a jealous mistress, as we were told.
A very jealous mistress.
And of course, a court doesn't want to know, well, I had a trial the day before, so I can't file submissions or whatever the
No,
case.
they would say, well, why didn't you hand up the brief? give it to another attorney.
Exactly. So
We was on quantum.
Yes, quantum.
We were on quantum. So how the court came to the figure. So I would read from at paragraph 140 of the judge's decision. This is what Justice Mohammed says. She says that it is settled law that awards of general damages for defamation must be considered in light of prior comparable awards. So what the judge did was not just dip in a hat and pick out a number. She carried out a judicial exercise by comparing like cases to Mr. Thomas's case. So she compared 6 cases. I'll name just a few of the 6 cases. So the matter with Anand Ramlogan, as he then was, the Attorney General, versus Jack Austin Warner. In 2015, the court awarded $800,000 in damages. That would have been general damages, aggravated damages, and exemplary damages. The matter of Ricardo Welch and Juliet Davey, the court awarded $700,000 in damages. The matter of Fayek Mohammed and Jack Warner, the court awarded $650,000 in damages. And a matter of Alfred Pierre, being an attorney, and Francis Moraine, the court awarded $900,000 in damages, and that was a 2019 matter.
Could you say why would the court have awarded such a high number, a high amount, sorry?
Because they kept increasing year upon year. Okay. So if we started from Anand Ramlogan and Jack Austin Warner, that was a 2015 judgment. And then the Ricardo Welch matter with the $700,000, that was a 2017 judgment. Then the court also cited the Andrew Gabriel and Philip Edward Alexander judgment. That was a $775,000 in 2019. So every year it goes up, just as inflation. So you have to make way for that. So from 2019 to 2023, you could see the rationale why the judge went with a figure of, well, it was about $900,000 in damages when you think of the general and the exemplary. So it was showing that the jurisprudence in our jurisdiction is that the damages for defamation is gradually increasing. It's not increasing astronomically, but it's increasing incrementally. Yeah. And she observed the dynamics of the personality, a public servant, I'd say a high-ranking public official, servant, the CEO of the NCRHA, the circumstances in which he was being defamed, in circumstances where he was doing his job, representing the country in terms of facing the COVID virus.
Yeah, and I'm saying, I'm certain, sorry to cut you across, but in addition to that period of COVID when the whole world is going through an issue.
Correct.
And your focus really is on making sure that you protect a life or save lives.
Save lives.
And you have someone who's trying to now, distract you.
And
I'm sure the court may have taken all that into consideration.
At minimum, you can say distract. At maximum, you say defame.
Yeah.
All right. So he was a distraction initially, but it came to a head when his superiors started questioning his integrity. So sometimes you try to ignore noise. Yeah. And certainly, I always say heavy is the head that wear the hat. It's hard being a leader. Yeah. And certainly to lead such a large organization, sometimes you have to be tunnel focused and focus. So what he was doing was focusing, even when I was telling him, let us send the pre-action now. And he was like, not now, because then he would have to change his focus from dealing with a pressing issue, life and death, to dealing with an issue that is personal to him. So credit to him that he held up for a while, but when we approached the court saw no issue in terms of issuing what you call an interim injunction. So there was an interim injunction in place for him to remove all the posts and to cease and desist. As we know, time goes on in terms of litigation. So this matter was filed in 2020. We got a decision in 2023.
Of course, notwithstanding COVID and the, there were a lot of court-bed suspension of the time.
Correct. So we make no qualms to that because we had the interim injunction in place. So that was a form of relief so that he could focus on his job. And that is a, how you call it, a tool that persons who are defamed can use. They can use the interim remedies of the court to at least maintain the status quo. The status quo being to ask the person to stop.
Yeah.
You know, stop what you're doing. Let us let the court decide if what you're doing is defamatory or not. All right, but don't just keep doing it, and you just frustrating my life while the court is trying to make a decision.
No, yes. I recall just earlier you stated that he had apologized to the defendant, but I don't think we got into the reason for his withdrawal.
Yes.
He sought counsel.
Well, he said he sought counsel, and the apology was made without counsel's advice.
Okay, fair enough. Until such time.
Correct.
Farai, let's take a pin there.
Yes.
We'll be right back after we take this break. You're watching Strictly Legal. And we are back on Strictly Legal with my guest, Mr. Farai Hove Masaisai, Senior Partner of Hoves and Associates. We are speaking on the defamation and technology, and before the break, we were dealing with the quantum in terms of the award of damages that the court awarded to the defendant, Mr. Thomas. I know we spoke all over the place in terms of the interest, etc., but just in terms of the precise award.
Okay. All right. So we had just left off where we were comparing the last authority of Alfred P. and Francis Morin, where the court would have awarded $900,000 in damages, and that was in 2019. Yeah. So if we fast forward to 2023, which would have been about that's 4 years. Yeah. 4 years. So 4 years going forward, we see that the court ordered. So in terms of the order, they say judgment for the claimant, and judgment for the claimant means that the claimant has won its case. So it's not that the court is passing judgment yes. on the claimant. So it's judgment for the claimant, meaning the claimant has proven its case and it has won its case. And then it goes on to speak as to what is your fruits of your judgment. So the fruits of the judgment for the claimant would be that the defendant has to pay him general damages in the sum of $800,000. That general damages will carry an interest rate of 2.5% from the 24th of June 2020, which was when he filed his claim, to the date of judgment, which is the September date in 2023.
And that is statutory interest? Or
no, that's just interest based on the going rate that the court awards interest on your damages.
So usually that's about 3 or 4%?
Yeah, right? Well, it can range. So I've seen it as low as 1.5. I've seen it as high as even the 5.
So in terms of this matter, what
the court awarded 2.5%. 2.5% on 800,000 over 4 years is...
That's a lot.
It's nice. It's a pretty little penny there.
That's a lot.
You know, yes. And then the defendant has to pay exemplary damages. So because of the outrageousness of the behavior, how it was concerted over many months, it was a concerted attack. The court said, here, what, 800,000 is not enough. So you have to pay 100,000 on top of that. So that would be 900,000. The court then granted injunctions. So the injunctions...
That's 100,000 he got for exemplary damages.
Extra, yeah. So that'll be, take it 900,000 and then you have your interest on top of that. So that alone might cross the million, right? Then you have the injunctions, so that the defendant, whether by himself, his servant and or agents, could be the very well Johnny Walker. who he says hijacked his device. They are restrained from publishing or causing to be published or republished any word statements or innuendos. So you can't even refer by innuendo anything defamatory of the claimant as complained in the pre-action. And
an innuendo could be basically you saying something without saying the person's name.
Correct.
Right? Yes.
Yeah,
because then they would already know that
correct.
This is
you could say head of NCRHA. Okay, well, who's the head?
Yeah.
So, and the restraint is to his Facebook page, and the court quotes his Facebook page. The court also ordered an apology, a public apology and retraction in writing of the allegations made in the post and authored by him and published on the Facebook profiles and the profiles of the third parties. And then the court finally ordered that he paid costs, and the court quantified those costs at $101,500. So those were the type of damages that the court awarded. I think the court wanted to send also a message to the armchair journalists who would think,
I mean, I have a lot
who would not think twice before they post. So I would suggest that you think twice, 3 times, and probably seek a legal opinion before you post something that is demeaning or not factual about a third party. In this case, the person who was posting did not even know Mr. Thomas. So that was one of the questions we would have posed under cross-examination. If it is that you're accusing him of all these things, is it that you know him? So why did you come to the conclusion that he did these things? So you have to be sure of what you're saying, sure of the greater the gravity of your speech, you have to do your due diligence. So it has to be backed up. So if it is you're saying that someone stole something, make sure you have your evidence that they stole that before you say it.
And I know during the break we were just chatting about, in terms of how the law has advanced. Like 10 years ago, Facebook posts wouldn't even be considered a defamatory statement.
Correct. I think before Facebook there was high five.
And then Facebook was really, we were in university during that time. That was a university. You had to have a university email,
correct.
Right, to join Facebook. And how technology has advanced, whereby now in the jurisprudence they are using that, as case law.
Even Twitter.
Twitter.
So you can get sued for a tweet. So careful how you tweet.
Yeah. Any social media platform down to this thing
Instagram,
that these people use now. TikTok that I refuse to join.
Yes.
No,
you can use it. Everything can be used for good and everything can be used for bad. Yes. It depends on what you choose to use it for. So some persons may use social media to boost their profile, boost their business. That is a good thing. But then some persons may use it to tear down someone. Yeah. And certainly that is where the courts come in. You can't just tear down someone's reputation that they may have built for their entire lives, and in some cases their family name, and expect no repercussions. And
another thing is that defamatory statements made via WhatsApp too. That is where there has been changes in law where the minute you post something like, while yes, it could be a private conversation, but then when you forward...
Once you screenshot, if you screenshot and you want to forward to a third party, then you better have your court closed.
Exactly, so people have to be mindful what they say on WhatsApp, who they say to, all the different
those
things.
WhatsApp chats.
The group chats,
The nature of it, WhatsApp has expanded the number of members that could join a chat.
Yes.
So just be careful when you want to argue with someone in a heated... You might get hot and flustered and you say something which you ought not to have said. But then 50 people in the 200 chat sees it.
And even screenshots, because they love to screenshot fast before you even...
No, correct.
Before you even delete.
Correct.
Before you even get the opportunity to delete.
Before you be able to delete all. And remember to delete all and don't just delete for yourself. No, I think social media should really be taught in schools now in terms of using it responsibly.
It will be interesting to know though, just it will be interesting to know whether or not, even if a supposedly defamatory statement was made and you delete it at the first possible opportunity right away, that delete all feature, whether the court can use that as sufficient defense to say, well, at the end of the day, it did not transmit.
Yeah. Now, in
larger population.
WhatsApp, there is that feature to see how many persons have seen your posts. All right, so the burden is always on the claimant to prove their case. So they would have to prove that third parties saw it. Yeah. So even if you post
that might
it
be hard
group,
because if they are not the author, they won't be able to know how many people see it.
Well,
unless you are the author.
Unless they bring somebody from the chat.
Yes.
Brethren, I know we in the same chat, but I need to get $1 million.
Yeah.
come and give some evidence.
Yes.
There. So you need to get your witnesses. Yes. The court is a court of evidence. So it's not about hearsay. You have to bring the person who actually saw it. So at least one person should have seen it, and they can give evidence on your behalf.
So technology is really advancing, and of course this in itself is just one of many.
It's just one of many,
right? I know a lot of persons. defamation occurs every day, but when we look at the monies now you have to spend, that's another factor too in terms of seeking legal counsel. I mean, how many lawyers may do this for pro bono until they get an award? And then you also have to look at, okay, yes, you are given an award, but whether the defendant has the means to pay the award, that's another consideration.
So that deals with enforcement.
Yes.
So with enforcement, there are different ways of enforcing. Certainly, I wouldn't want to let the cat out of the bag in terms of what we're going to do, but there are many ways to enforce a judgment, including contempt of court proceedings, where persons can be put into jail for not complying with a court order, seizure of property, garnishee orders, and so forth. So there are different methods to enforce a court order, but a court order is a court order, and we have to respect that.
Like for instance, I would advise my clients, particularly when it comes to defamatory statements, yes, send your pre-action, I mean, we can send pre-action protocol letter and all these different things, but sometimes you find that there are people who make defamatory statements, they don't even own a house, they don't even own any assets, you know, so it's whether or not, yes, some people may want to go all the way to clear their name.
Correct.
So sometimes either clear their name or you want the money.
I suppose the higher you are in terms of the reputation chain, you want to vindicate your name.
Correct.
So it may not be about the money. For Mr. Thomas, it was never about the money, it was really about the vindication of his good name. So it depends. Some persons may say, well, I want to vindicate my name, but still mature, not to go to university.
Correct, yeah.
You know, so
I mean, if it's a defender with means, yeah.
Correct.
And this goes to the publishing company. I know this is a Facebook matter, but for instance, if defamatory statements were made by an individual on a television program.
Correct. So you're allowed, because of the law of vicarious liability, to go against the employer as well. So if it's a
usually that's where you get the monies. That's where the monies will come if you have a good case.
They are liable individually and separately. So you can choose who to get, but you can't get the same amount from everybody.
From everyone.
You know, so that's why I suppose most employers now, they would put something in the employment contract to protect them from that vicarious liability if they are hiring a loose cannon. You know?
and I'm assuming this is the case with Facebook. That's why Facebook is not party to litigation.
No,
because
they have disclaimers and
policies.
Different policies that if they basically wash their hands from what the user does there in that jurisdiction. So yeah, so for us to sue Facebook, we would actually have to go to their jurisdiction. It would be a jurisdictional issue, but it doesn't prevent us from suing the Facebook user in our jurisdiction. Yeah.
Now, for a small country, Farai, do you think that we are? I mean, we are a litigious society. I believe so.
I think we are. I think
for a small society.
In the Caribbean, we are always at the cutting edge of litigation. For example, we are the biggest subscribers to the Judicial Committee of the Privy Council. Every month, you probably see 3-4 judgments coming from our jurisdiction at the Privy Council. So, and the other islands, our Caribbean neighbors, including Jamaica, they look to us for our authorities. A lot of our practitioners, they practice regionally, you know. So, yeah.
And of course now with the advent of COVID, everything is virtual.
Correct.
Right. So therefore,
all you need to do is get call to the bar. Don't do a micros, you know, in suits.
Yes.
You know, don't be a micros, but get called to the local bar and you can practice. I have a colleague from Trinidad who married a Bajan. So his wife is Bajan. Yeah, his wife is Bajan. And he lives in Barbados, but he practices in Trinidad.
Yeah. Because the court no longer, I don't even think it's part of the practice direction. Maybe I can stand corrected. But I don't think the court even concerns. Prior, the court would have been concerned, okay, you have to be in Trinidad, right? Even if you're
correct
virtually. But now, you can be anywhere in the world and the court will not even know where you are.
Including with the Judicial Committee. So they have hybrid hearings now. So it's a choice. They ask you, if you say, Mr. Masaisai, do you want to come to England or do you prefer to have the matter heard hybrid? Meaning the law lords will sit in the Privy Council and the attorneys will sit wherever they are in the jurisdiction.
I mean, if a client have the means and paying for your trip.
No, well, it saves, you see, that was one of the things with COVID. Yeah. COVID allowed for greater access to justice. So I'll put a plug into the...
Particularly Privy Council, eh?
Correct. No, but I'll put a plug even into our judiciary in terms of their administration. They adopted the virtual system with open arms. They were not abrasive to it. And for me, it allowed for attorneys as stakeholders in the process to be able to allow, well, certainly pass that savings on to their clients, whereas before you would have to physically file something in San Fernando if the case started in San Fernando. Now you could just scan it, upload it, and email it to your learned friend. You know? So it saves a lot of money. You know, it saved a lot of money. It saves a lot of time. You don't have to
rush into court 3:45. You're trying to rush to file something before 4, and you get an attitude.
So I put a plug in there. I hold no brief for the Chief Justice, but I put a plug in there for the Chief Justice and his administrative team. And long may the virtual court system live. And
trust me, I don't think we could ever go back fully to physical court. I think attorneys might end up just firing the work. So because after you get so comfortable, I mean, you and your client and the judicial officers, I mean, who want to see you all the time in front of their face?
I had a case once where on the other side, the witness was cooking. So she had a pot boiling and she was giving evidence and she asked the judge, she said, "My lady, I think my rice burning." And the judge,
what the judge said?
The judge said, "Go and take off your pot."
That's a good judge. Another judge, according to where she went to buffet before.
Right? No,
that's funny. Because life, life happens at the end of the day.
Correct.
You know?
And for example, with expert witnesses, if you were to have an expert in, say, medical negligence. Most experts in medical negligence cases have to come from outside if you are suing the state. Not because many doctors are consultants with the state. So you have to get an expert in, say, from England or from Barbados or anyway. They can sit in their jurisdiction and give that expert opinion.
BC, and when I say BC, I mean before COVID. BC, that you had to spend monies to bring these experts down.
Correct. House them.
Correct.
And then they're not housing in Cape Park. They want Hyatt.
Yeah. It reminds me of a trial I did in intellectual property matter, and I had to bring an expert witness who was a big music producer for Michael Jackson at the time, down to Trinidad. My client had to pay for that. Dexter Simmons, I mean, everyone knows who is he. And, you know, and they had to pay for that. I mean, if it's now, he just have to...
Yeah, just put his phone, wherever he is in the studio, just lower down the volume. Yeah. You know?
I know it had clients literally driving the car down.
Well, the judges might tell us, pull over. They will tell you, pull over. You know, but the access to justice has increased. I would safely say it has increased. We are indeed a litigious society, but that is because persons are becoming more aware of their rights, and certainly in no short order because of shows like this.
Yes.
You know,
and particularly, you see defamation. Our society we love keyboard, we love bacchanal, and sometimes it is really important to drive things home. Two persons that
there is a
you
line.
Cannot just say anything.
Correct.
There is a line, and a very thin line.
Very thin
line. And it's very, as you said, access to justice is easy. It has attorneys who will be willing.
Yeah.
Once you have a winning and compelling case, an attorney will be willing to take up your matter.
Don't defame anybody who's popular. All right, maybe a little vagrant on the road, you could say, "Boy, look how stinky he is."
Yeah,
you're telling the truth. You know, you would say you're telling the truth, but don't defame a man sitting in Parliament.
Yeah, boy.
Don't defame a man who's a CEO. Watch at the office. Don't just hold back now.
Yes.
Bite your tongue. Bite your tongue.
Because according to a client of mine, he said we had the budget. We had the litigation budget. We go sue.
Correct. And the nature of it is persons who are suing for vindication of name, they tend not to want to stop until their name is vindicated.
Indeed.
You know, especially if they know what is said was untrue.
Yeah.
You know, if you know it's true, then you really need your evidence. That's the thing. So, yes, we are a litigious society. And we are the cutting edge, and it's no fault to us. It's probably up with regards to how our judiciary has developed over the years.
Yeah, I must say, and we must commend the judiciary and the Honourable Chief Justice.
Yeah.
There's much work to be done. you know, but I think we have advanced. I mean, I see much work to be done. Probate is another thing. But
criminal is another thing.
Yes, the criminal is another thing. But I must say the civil and family jurisdiction.
Civil and family, yes.
The court has been really trying and really doing great. For right now, in terms of the way forward in this matter, is this I mean, I know there's, as you said, there's a stay.
Yeah, so so normally with orders, judges will give a stay for a short period.
And when you say a stay, just explain to the public.
A stay basically is that you cannot enforce your order until the stay has been removed. So the stay is for 30 days, and it's really to allow the parties, because we got the judgment on the day we got the judgment. So it allows the parties' attorneys to study the judgment and consider whether or not they want to appeal. So everyone has a right to appeal. It's a constitutional right. So if Mr. Siwa wants to appeal, he can appeal. We can cross appeal if we choose to. But yeah, so that is really the purpose of the state. It's 70 pages. Read it.
Yeah,
if you find any fault in it that you think a higher court may want to correct, you're allowed to appeal. And the other side is allowed to cross appeal if they so desire.
Do you foresee there being an appeal in these circumstances?
In my mind, a case doesn't stop until the fat lady sings, and the fat lady for me is always the proverbial privy council.
Right.
So I accept first instance decisions, but because of the practice, you know that a party can end up in the privy council in the next 4 years. You know, so you don't celebrate too early, because we have a 3-tier system of judicial justice.
Yeah.
So this is the first round. It could be a second round, it could be a third round. But certainly we have won the first round.
First round, and at the end of the day, your money show. Your money show. So Farai, tell us, in closing, in terms of you know, where you see the law of defamation. I mean, I know we have advanced, but in terms of, is it at the correct trajectory?
Yes.
In terms of digitally?
Yeah. So in terms of how we police the social media, it is good that the judges are not shying away from it. We are not only focused on the traditional means of defamation, traditional being radio, print, verbal, but we have gone into the social media, and the judges have embraced it. They have, even in this judgment, the trial judge did speak to social media experts. Can be something that we can bring in the next dispensation of a trial.
Social media experts, that's interesting.
Yes, because what we were trying to explain to the judge in our layman's terms, how algorithms work and how it can reach from 1,000 people viewing it to 1 million persons.
According to who is commenting,
correct,
who is sharing.
Correct.
Yes.
So, but the judge was like, well, we did not have a social media expert in the court, so the court cannot take counsel's layman's opinion.
And this is something that the court even recognizes, that there is a profession.
Correct.
As known as a social media expert.
Social media managers.
Because we see it now. Yeah, they are paid for that.
And that's what I was saying, that in schools, you see, social media can be used for good, it can be used for bad.
Yeah.
And the good is that social media is an economy in itself.
Yes.
So why are we not teaching it in schools? Why are we not teaching students from primary school how to use social media for good?
And it's recognized because you have prominent jobs actually advertises social media.
I think now in probate, for small probate estates, they put it on Facebook.
Oh, okay.
Judiciary's website for small estates.
They do. Yes, they do that, so and they use their Instagram and their
correct, and
Facebook
it costs less than paying in. Well, I wouldn't say anything because I'm in a media house, but yes, social media is something that is being embraced by the judiciary. It's being policed by the judiciary. I just say that in the wider society, especially in the schools, they must accept that social media is indeed now a economic area, an area where young persons, especially young persons who would want to, who are savvy, they call it social media savvy.
Yes.
I have a son who is 10 years old, and he is more savvy on the Instagram. Well, he uses my Instagram. He does my Reels.
Oh, okay.
Reels, you know, so I don't know. I don't know what I say, but once you don't make me do anything
Junior
too funny,
easy.
you know, but the reality is he knows how to do it.
Yes,
and I don't.
reality.
You know,
reality.
he knows how to crop the videos on the phone, and he's like, no, that's too long, and people ain't go watch it.
These 10-year-olds are not like us when we were 10, when we didn't know about social media.
Yeah, they're on their smart devices. The teachers should teach them to use it for good.
Yes, correct. So Farai, we are out of time. I mean, this was interesting. Your final words quickly.
Yes, no, well, it's always a pleasure to be here with you, Rondell. Definitely, I say thank you to you and your producers for having me on the show. And certainly, I hope I would have added some value to your listenership.
Indeed, you have, and congratulations. Yeah. We will take a drink somewhere,
yes.
A coffee somewhere when you get your award. Thank you so much, Farai. You have been watching Strictly Legal on WESN Content Capital. I had Mr. Farai Hove Masaisai of Hove and Associates, attorneys at law, talking about defamation and the digital age. Thank you so much for watching. And before I go, of course, I leave you with this quote: if you cannot do great things, do small things in a great way. God bless. Have a good day.